Hello and welcome to this year's HK45 annual update. My name is Tara Liao. I'm a barrister practicing from Danshan Chambers and I'm a member of the HK45 committee. We have a great lineup of speakers today covering a variety of topics in this 1-hour webinar. Our first speaker is Mohamed Talib. He specializes in international arbitration with a focus on the infrastructure sector. He's also a solicitor advocate in Hong Kong and thus trials advocate in relation to construction and engineering disputes. He's going to talk to us about conditional fees and conclusions to the consultation on outcome-related fee structures. Our second speaker is James Mann. He's a barrister practicing from Temple Chambers. He has a broad civil practice and experience in international arbitration and have acted for high net worth corporate clients across China, Europe, and the US. He's going to talk to us about recent Hong Kong cases on escalation arbitration clauses. Our third speaker is Shirley Tong. He's a partner in the International Arbitration and Litigation team at Withers Worldwide. She's based in Hong Kong and she specializes in cross-border corporate and commercial disputes. She's going to talk to us about recent Hong Kong cases on enforcement and setting aside of arbitral awards, and also the impact of the CISG on international arbitration. Our fourth speaker is Elizabeth Chan. She's a registered foreign lawyer at Allen & Overy in Hong Kong, specializing in international commercial arbitration and investment treaty arbitration. She's going to tell us about the impact of the metaverse and virtual reality on international arbitration. Now, just a couple of housekeeping points. This session is being recorded and the lines of the audience are muted, but there will be a Q&A box where you can type in your questions, which the speakers will endeavor to answer if we have time at the end of the session. Now, without further ado, I will hand it over to our first speaker, Mohamed. I'm sorry, just to make sure, Mohamed, you are now unmuted.
Sorry, my screen sharing crashed on me, and I'm just going to try and bring that back. Give me a second, please. Okay, here we go, second time lucky. Right, so the topic today I'd like to talk to you about is outcome-related fees in Hong Kong arbitrations. Now, under the current law in Hong Kong, as some of you may know, lawyers are prohibited from providing arbitration funding in situations where the lawyer or their legal practice is acting for a party in the arbitration. And in December 2021, the Law Reform Commission published their report on outcome-related fees in arbitration. And the key recommendation from that report is that outcome-related fees should be allowed, so that lawyers in arbitration will be able to charge such fees. And so what I'm hoping to do across the next 10 to 12 minutes is to look at the main recommendations that came out of that report and highlight what's going to happen next. So here's the starting point. In law, nothing is certain but the expense. So the report identifies 3 types of conditional fee arrangements that can be used. They all have catchy acronyms: CFAs, DBAs, and hybrid DBAs. And I suspect we're going to be hearing those acronyms a lot across the next couple of years. So what's a CFA? A CFA is an agreement for a client to pay a lawyer an additional fee, essentially a success fee, if they are successful. It can be an agreed fixed fee, or it can be a percentage uplift on their existing costs as charged by the lawyer. This can be contrasted with a DBA. We've probably all seen plenty of DBAs in American novels, TV shows, and movies. A DBA is essentially payment of part of the sum recovered in the proceedings. It's basically a contingency fee arrangement. It's where the lawyer takes part of the damages awarded to the party. And then we have the hybrid DBA, which brings together a CFA and a DBA and combines their effect. So it's a situation where the lawyer receives a reduced hourly rate upfront, and that's payable regardless of whether they win or whether they lose. And then there's a contingency fee arrangement in the event of success that gives them an uplift. So at its heart, why are we making these changes? We have a great quote here from Lee Kuan Yew: "The acid test of any legal system is whether in fact it is able to produce order and justice." And in part, it's Lee Kuan Yew, it's Singapore, it's the global arbitration market, and a whole other factors that are driving this change. So the reason the Law Reform Commission gives for introducing outcome-related fee structures into arbitration in Hong Kong is that it's necessary to preserve and promote Hong Kong's leading position in the market, its competitiveness rather, and to enhance access to justice. And importantly, to give clients freedom and flexibility in pricing arrangements. So for Hong Kong to remain a leading arbitration hub, it is essential that we can offer what lawyers throughout the world are able to offer, most recently what lawyers in Singapore are about to be able to offer. And that's part of the rationale that the Law Reform Commission highlights, which is the ability to compete with other jurisdictions when it comes to legal fees for arbitration work. Winning isn't everything, it's the only thing. And this is absolutely true when it comes to conditional fee arrangements and success fees. The very first recommendation that we have from the Law Reform Commission in the report is that the prohibition on the use of conditional fee arrangements by lawyers should be lifted, so that lawyers can enter into such arrangements if that's what they want to do. Now, there are essentially three main prohibitions on conditional fee arrangements and really all forms of outcome-related fee arrangements in Hong Kong. There are two that are really important. The first is Section 64 of the Legal Practitioners Ordinance, which essentially says that there's no validity to any success fee or contingency fee arrangement for a solicitor in Hong Kong. And the second is at common law, where the doctrines of championship and maintenance still continue to have a bite. And we've seen that from recent decisions in the Court of Final Appeal. Unruh and Seeberger and the Winnie Low case confirm those are still applicable in Hong Kong. And of course, not as important because it depends on the other two, but it's still there, is Principle 4.17 of the Solicitor's Guide, which prohibits a solicitor from entering into a contingency fee arrangement in contentious proceedings, and there are equivalent provisions in the Bar Code in relation to contingency fees and success fees. So all of these things need to be unpacked, and that's one of the things that this is covering in Recommendation 1, is that we should be permitted as a matter of law, as a matter of ethics, as a matter of professional conduct, to be allowed to enter into such arrangements. Now, there's no success without hardship. Just because you can enter into a conditional fee arrangement doesn't mean you get to keep all of the upside and none of the downside. So the second recommendation that came out of the report is that where there's a conditional fee arrangement in place, any success fee premium and any legal expense insurance that's agreed by the client with its lawyers and its insurers cannot in principle be recovered from the unsuccessful party. However, there is a residual discretion, so the tribunal can, in exceptional circumstances, allow and make an order in respect of such costs. Now this system really exists because there are two aspects to any conditional fee arrangement. One, which is the after the event insurance for costs, by which the client tries to make sure that even if they lose, they don't take on the liability to pay an adverse cost order. And also the success fee, which is their contribution to the legal costs in the event that they succeed, over and above the ordinary costs of the litigation. Previously in other jurisdictions, the position was that you could recover these elements, and globally what we've seen is a backtracking, so that the legal insurance premiums and the success fee element are no longer recoverable in many jurisdictions. And really what this reflects is the fact that the recovery of such costs is a huge bonus to the claimants, who are by far the greatest users of these kind of fee arrangements. In effect, if they could recover the success premium and the insurance premium, they could litigate risk-free and transfer all the costs onto the defendants if they lose. So what's the next recommendation? Recommendation 3 is in relation, well, sorry, I'll skip ahead to recommendations 4, 5, and 6. Recommendation 4 is essentially permitting the use of DBAs, contingency fee arrangements, And the logic here is that there is no reason to permit conditional fee arrangements and success fees, but prohibit debt-based, damages-based agreements and contingency fees. And recommendation 5 confirms that the position for DBAs is the same as the position for CFAs when it comes to legal expense insurance. Essentially, unless there are exceptional circumstances. So rather, they should be borne by the claimant and or the litigant or the funded party. And in the event that there is success, they can't be recovered from the other side, but the tribunal has the residual discretion to allocate such costs if it needs to in exceptional circumstances. And then we have recommendation 6. Now, recommendation 6 is actually quite complex. It's a navigation of 2 alternative models of damages-based agreement, one known as the Ontario model, which unsurprisingly is the model used in Ontario, Canada, and the other known as the success fee model, which is essentially the model that is being advocated in England and Wales. And what the success fee model essentially means is that the costs recovered from the opponent are outside of the scope of the damages-based agreement, outside of the scope of the money recovered by the lawyer under the DBA. And that's the model that is adopted and recommended in the Law Reform Commission's report. There are the 2 aspects of DBA arrangements that are worth highlighting that are set out in recommendation 7 and recommendation 9. Recommendation 7 essentially provides that any final DBA payment, so the actual portion of the damages that are taken home by the lawyer, are capped at 50% of the total financial benefit obtained by the party in the arbitration. Now, financial benefit is a complex idea, and it's set out in full in the report, but the idea is it's money your money's worth. So it's the actual money or the assets, the shares, the IP rights, or other tangible or intangible property that are actually recovered in the arbitration. But what's not included in that sum is the money recovered as by way of legal costs in the proceedings. And in practical terms, what that means is that you can have no more than a 50% share of the money that the client recovers from the arbitration. That's the top, that's the ceiling level. Recommendation 9 is quite complementary to recommendation 7. And essentially what it recognizes is that we've got more than one kind of lawyer in Hong Kong, for barristers and solicitors. And so that the 50% cap applies to the total take-home amount of both barristers and solicitors under a DBA. And it's a matter of agreement as to how you treat some payable by barristers in respect of barrister services and some payable in respect of solicitor services, but the total amount can't go over 50%. That takes me on to recommendation 8. If you want a happy ending, that depends, of course, on where you stop your story. And what recommendation 8 tells us is that there should be a provision in the CFA agreement, the DBA agreement, or the hybrid DBA agreement on the ground at which it can be terminated before the end of the arbitration. Now, these are meant to be contractual grounds to be negotiated and agreed between the parties, but there's also then a fallback position as a matter of subsidiary legislation, which is expected to go on and specify on a non-exhaustive basis when such termination can be done, such as where the client has committed a material breach of the agreement, or the client has behaved or is behaving unreasonably. I've jumped ahead. I talked about hybrid DBAs, and hybrid DBAs are also one of the things that are permitted under the report. Hybrid DBAs, as I mentioned earlier, are a combination of a conditional fee arrangement and a contingency fee arrangement. And essentially what recommendation 10 tells us is that such hybrid arrangements are permitted. And then it provides the very complex rules on how you deal with the costs of a hybrid DBAs. If the claim fails, the lawyer can only keep a portion, namely 50% of the benchmark costs for the unsuccessful claim. On the other hand, if the claim succeeds, but the lawyer is entitled to recover less than 50% of the capped costs, then the lawyer is entitled to retain the capped amount of the irrecoverable costs. This is all really quite complex. You probably need to actually look at the report and map out some numbers and some formulas for this to make sense. And I think actually it's one of the areas where the report could have been a little more helpful in shedding a bit more guidance about how the fee arrangement works for DBAs. Because in practice, what we see in other jurisdictions where DBA arrangements are permitted is that the hybrid form of DBA is very commonly used. And if not the dominant, it is one of the most dominant forms of funding arrangement that is used. Right. So some other key points that arise out of the final recommendations in the report. Recommendation 13A says that we're going to have subsidiary legislation. And it then sets out a number of things that are going to be covered in the subsidiary legislation when it comes into force. One, the agreement is going to need to be in writing. So you're going to have to admit to your client that you're making money, and you're going to have to explain to them how you're making money. So you need to tell your client anything that's relevant in a clear and accessible form. The client has to be told of their right to seek independent legal advice and will actually be required to confirm in the agreement that they're aware of this right. There's going to be a 7-day cooling off period so that if there's buyer's remorse, there's a chance for the client to walk away from the funding arrangement that they've entered into and to terminate the agreement. And finally, the agreement is going to need to specify clearly what fees and disbursements are payable, especially when the agreement is terminated by either party. So if you have a situation, especially if it's terminated during the course of an arbitration, you still need some formula, some mechanism, some method to work out how the fees are going to be calculated. And that's what's required under the subsidiary legislation. Recommendations 13G and 13H have a carve out for personal injury claims. It's an interesting carve out because they're often the claims that are needed to be funded from an access to justice and a funds available sort of perspective, but that's a policy decision that is adopted by the Law Reform Commission. And recommendation 14 expects that provision is going to be made in the subsidiary legislation to explain how we are going to deal with different stages of the arbitration and court process. So it recognizes in principle that different stages can have different funding arrangements and that you could divide up the way the funding is structured. And we'll need to have some clarity around how that is going to work, and that's going to come in the subsidiary legislation. So what's the reaction been to these changes? The arbitration community's reaction has actually been overwhelmingly positive. The view is these are changes that Hong Kong needs to make to ensure it's competitive and flexible when it comes to pricing. But there are some concerns about these recommendations and what they're going to look like in practice. This can be generally categorized into about 4 categories. There are those who are worried about the conflict of interest and the risk of unprofessional conduct. There are those who are worried about increasing legal costs, not necessarily fees, but actual costs, and driving opportunistic litigation. And then there are those who are worried about the risk of satellite litigation, especially satellite litigation about fees. Now, these kinds of challenges are really well-trodden ground, and there are no real difference between them as they've been articulated in Hong Kong and how they've been articulated in almost every other jurisdiction where these kind of fees have been considered. So what happens next? The DOJ now needs to consider these recommendations, and that if they accept the recommendations, they then need to be turned into law. What law does it need to be turned into? We need to see amendments to the Legal Practitioners Ordinance. In particular, we need to see changes to Part 10A of the Arbitration Ordinance, and we're going to need to see some idea of what those changes are going to look like. Actually, in Appendix 1, Annex 1 of the report, they have set out what they suggest to be the changes made to Part 10A of the Arbitration Ordinance. And I think those are well worth looking at to give you an idea of what the scheme will look like once it comes into law. We're also going to need amendments to our professional ethics regulations in Hong Kong. We're going to need to consider whether ethical safeguards and ethical requirements need to be put in place before lawyers can counsel clients to adopt such arrangements, and what sort of steps need to be taken before they can protect themselves ethically. And we're going to need to see the subsidiary legislation. In the report in Annex 2, it sets out the number of points that are going to be covered in the subsidiary legislation, but we need to see a final form of what that's going to look like in practice. Now, the reality is in the past, we've seen arbitration-related changes made very quickly in Hong Kong, and we can remain optimistic that if the Law Reform Commission's recommendations are adopted, we'll see alternative fee structures and outcome-related fees in Hong Kong in the next few years. So that was a very quick trot through a very long report. But if there are three things that I think we can take away from it, here they are. The report supports the adoption of three types of funding models: CFAs, DBAs, and hybrid DBAs in Hong Kong. We're going to need amendments to the arbitration ordinance and our legal and ethical codes to make this happen. And when it comes into practice, you're going to have to look very carefully at the legal and ethical safeguards for clients that have been implemented before you enter into your first conditional fee arrangement. That's a quick hybrid run through of the law reform report. And now I'll hand over to James to talk you through escalation clauses.
So today I'm going to provide an update on the recent Hong Kong cases on what we know to be escalation arbitration clause or multi-tier clause. So many of you would be familiar with such type of clause. It is a dispute resolution clause that, because the parties' agreement that any dispute between the parties shall be resolved on a staged basis. So for example, parties can first agree in the first stage that there should be a consultation to resolve their difference on the matter. And then after X number of days, if consultation does not result in any outcome, they can go to arbitration. So on the screen, you can see an example of such an escalation clause, which I extract from the English case Emirates Trading Agency. Which parties shall first seek to resolve the dispute or claim by friendly discussion. If no solution can be arrived between the parties for a continuous period of 4 weeks, then the non-defaulting party can invoke the arbitration clause and refer the dispute to arbitration. And in fact, this type of clause is quite common in PRC-related contracts. But in Chinese, it's 經過友好協商, and then they would then refer the dispute to arbitration. So this is now quite a common type of clause that we can find in commercial contracts. And so what are the practical problems that we would face in dealing with such escalation clause? Usually, parties often dispute on whether such an escalation clause is complied with prior to the commencement of the arbitration proceedings. Using an example clause that I show on the last page just now, it will be whether a friendly discussion has indeed taken place between the parties. In some other instances, for example, when parties appoint a third party to rule on or adjudicate on their difference on the subject contract, the dispute then can be whether such a third party is qualified as prescribed pursuant to the contractual requirement, something like that. And this is about the substantive aspect of the escalation clause. And in terms of procedural aspects, this is an important question of whether an escalation clause goes to the question of jurisdiction or the question of admissibility. So what is meant by the question of jurisdiction? Broadly speaking, it is whether the arbitral tribunal has the requisite power to hear the case. And what is meant by admissibility? Roughly speaking, it is whether it would be appropriate for the tribunal to hear the case. So the first way is about whether the tribunal has a jurisdiction, has a power. The latter one is whether it is appropriate, whether the claim or the dispute is admissible for arbitration. So what are the distinctions between the two? If the issue of compliance of the escalation clause goes to the question of jurisdiction, then the consequence will be, firstly, the tribunal can rule on the issue, because we all know the competence principle. The arbitral tribunal can always rule on its own jurisdiction. But the more important aspect of the question being a question of jurisdiction is that the ruling would then be open to challenge by the losing party in court on the ground that, oh, this is not correct. The tribunal's ruling on its own jurisdiction is not correct. And it is quite well established that if a matter goes to the question of jurisdiction in terms of whether the arbitral tribunal has the power to hear the reference, then the court can review the question of jurisdiction on a full-blown basis. And whatever the views the tribunal gave in its ruling on jurisdiction, it won't have any legal or evidential value. It's well established in a Supreme Court case known as Dala Real Estate and Ministry of Religious Affairs of Pakistan. In contrast, if the question goes to the question of compliance of the execution clause goes to the question of admissibility, then the consequence will be firstly, again, the tribunal can rule on the issue, but this time the decision of the tribunal will be final and will not be open to review by the court, except on those narrow grounds on setting aside an award. So it won't be a full-blown review, it will be a very narrow ground of reviewing the decision of the tribunal on the issue. It's unlike if the matter goes to the question of jurisdiction, then the court can do a full-blown review. It is entirely different. It would be almost final, and you can only challenge the decision of the tribunal on that ruling on more like a procedural or public policy basis. And in 2021, there were a few Hong Kong cases which addressed the question of jurisdiction versus admissibility concerning the escalation arbitration clause. The first case is the decision of the Honorable Mr. Justice Godfrey Lam. And what happened in that case is that, as I set out in the PowerPoint, in December 2011, C&D entered into a cooperation agreement for the development and building a satellite. The agreement provided that the parties shall attempt in good faith promptly to resolve any dispute between them by negotiation, and either party may, by written notice, refer such dispute to the Chief Executive Officer of the parties for resolution. And that if any dispute could not be resolved amicably within 60 business days, a party's request in writing for such negotiation, it shall be referred to arbitration in Hong Kong. And then quite a number of years later, in December 2018, the defendants, the D's CEO issued a letter to the chairman of C's board of directors alleging that C committed a repudiatory breach of the agreement and that D was willing to refer the dispute to the parties' respective senior management teams. And in January 2019, C solicitors requested that all further correspondence be directed to them or addressed to C's CEO. But there was no such further correspondence from D, nor did C refer the dispute to the CEOs. Then in April, D issued a notice referring the dispute to arbitration. And then in April 2020, the tribunal issued a partial award, rejecting C's objection to jurisdiction on the basis that the reference of disputes to the respective CEOs in clause 14.2 was optional, and the condition in clause 14.3 was satisfied by D's letter in December 2018. It was further held that C was in breach of the agreement and had to pay damages. And C applied for declaration under the arbitration ordinance, and that the award was made without jurisdiction and was not binding on C, and for an order that the award be set aside. So basically, C is saying that the execution clause prior to the arbitration has not been complied with. He wanted to use that as a basis to set aside the arbitral or the ruling of the arbitral tribunal in that regard. So what Mr. Justice Lam, he then was told that is that, firstly, although the characterization of contractual procedural requirements varied amongst different legal systems, the general held view of academic works, international tribunals, and national courts was that non-compliance with procedural pre-arbitration conditions, such as a requirement to engage in prior negotiations, went to the question of admissibility rather than jurisdiction. So he held that the question is one of admissibility, but not one of jurisdiction. And the distinction between jurisdiction and admissibility was not one only that to be drawn on the specific wording of the written law of a particular jurisdiction, but was a concept rooted in the nature of arbitration itself. It was consistent with the policy in Hong Kong law that which respected the parties' autonomy in choosing arbitration as the means to resolve their disputes, with its incident of speed and finality as well as privacy set out in the ordinance. And multi-tier dispute resolution mechanism were not uncommon. It would not be conducive to swift dispute resolution if controversies regarding procedural conditions such that in the case were regarded as jurisdictional questions, opening the way for duplicated arguments in court proceedings. So basically, from a policy perspective, from the objective of speedy resolution on arbitration, the court said that, oh, this should go to the question of admissibility, such that the decision of the tribunal will be final and not open to review by the court. And then I just try to draw to your attention to paragraph 36 of the judgment, which said after deciding upon the jurisdictional challenges, arbitrators may also be called upon to decide on the admissibility of the claim. This may include a determination as to whether a condition precedent to referring to referring the dispute to arbitration exists and whether such a condition has been satisfied. It also involves challenges that the claim is time-bound. So basically, one of the observations made by his lordship is that, well, this is an admissibility question, and it's quite common in international arbitration that the tribunal can direct the issue of admissibility to be determined, to be dealt with in the earlier stage of the arbitration. And what advantage does this have? In paragraph 49 of the judgment, he further explained, the fact that a condition is regarded as going to admissibility rather than jurisdiction does not mean it is unimportant. What it does mean is that the arbitral tribunal has jurisdiction and may deal with the question as it sees fit. If it comes to the view that the earlier stages in a multi-tier dispute resolution clause have not been fulfilled, it can give effect to the contractual requirement by, for example, ordering a stay of the arbitral proceedings in whole or in part, pending compliance with the clause, imposing court sanctions, or even dismissing the claim outright as inadmissible. This approach has considerable advantages. For these clauses can be complex in their operation, and the arbitral tribunal chosen by the parties agreed mechanism will usually be well placed to consider and determine what is to be done, having regard to commercial realities and practicalities, including whether it will be futile to compel the parties to go through the motions. So the long and short of it is that since the question goes to the issue of admissibility, the tribunal can exercise its procedural power to decide this question of admissibility at an earlier stage. It can either say that, oh, this claim is not admissible at all, please go back, I will dismiss the claim outright, or if something can be done to remedy the situation, that it can order the parties to do so. And of course, the wrongful party may be imposed cost sanction upon that. But the advantage of this mechanism, of this being classified as a question of admissibility, is that it can be dealt with at an early stage of the arbitration, and it gives the tribunal a flexible power to dispose of the issue at the early stage of the arbitration. So all this would be consistent with the objective of the arbitration being a speedy resolution of the parties' disputes. So, as I said, the lesson learned is that we know that this decision encouraged the tribunal to determine the issue of compliance of escalation clause at the early stage of the arbitration, and such decision will be final. And C&D is indeed, as far as I understand, the first Hong Kong authority certifying that escalation clause or multi-tier clause goes to the question of admissibility as opposed to the question of jurisdiction. And then there was the second case on this topic, the decision of Kinji Civil Engineering Limited and Geotech Engineering Limited, also in 2021, a decision by the Honorable Madam Mimi Chan, who is currently in charge of the construction arbitration list. The facts of this case are not important for present purposes, but at paragraph 8, she basically confirmed the decision in C&D. And finally, there's the third case, T&B, is a decision of Mr. Justice Coleman. Given the time, I'll skip the facts because it's more important to know what is the decision and the ratio of that case. Basically, there is also a dispute on whether a particular requirement under the escalation clause has been complied with, and the court dismissed the plaintiff setting aside application, holding that non-compliance with the arbitration procedure should go to the question of admissibility, because the plaintiff in that case, like the party in C&D, also tried to set aside the ruling of the tribunal on the basis that it should be a question of jurisdiction. But Mr. Justice Coleman said, "Oh, this is not a question of jurisdiction. This is a question of admissibility, and in that regard, it should not be reviewed by the Hong Kong court." And just to point out a particular paragraph in that judgment, because that paragraph highlights again the important policy objective of classifying the escalation clause or the issue concerning escalation clause as a question of admissibility rather than jurisdiction. In paragraph 22, he said, adopting the admissibility vis-a-vis jurisdiction distinction, it makes sense. Conceptually, it respects the parties' autonomy. It is in line with the general trend of judicial restraint from interfering with parties' agreed dispute resolution regime. It serves the object of the arbitration ordinance, which is identified as to be facilitate the fair and speedy resolution of disputes by arbitration without unnecessary expense, and it will serve to bring Hong Kong in line with the wider international arbitration communities. So these are all the advantages of this classifying the issue to be one of admissibility rather than jurisdiction. So these are basically the recent cases on this topic. And to conclude my updates, there are, of course, other issues about escalation clauses, such as whether a mere agreement to negotiate in good faith or 友好協商, whether they are really sufficiently certain to be enforceable. There are different views on this issue. There has been an English case saying that it is sufficiently certain to be enforceable, but it is also subject to heavy academic criticism, such as one of the leading texts on the jurisdictional clause by David Joseph QC. So this issue may need further clarification, but well, it seems unlikely that the Hong Kong court will have a chance to rule on the issue, because if all these issues go to the question of admissibility, that means that in future, there may be little chance for the Hong Kong court to further comment on other issues relating to escalation clause. And this is one of the maybe an unintended consequence. But given the overall important objectives that escalation clause can serve, given that how classifying it into an issue of admissibility can bring good to the general arbitration community, and how it's being consistent with the objective under the ordinance. So this is where we stand now, and I will now pass to Sherlyn to talk about what she needs to talk today. Thank you.
Thanks very much, James. I'm going to now attempt to use my technical skills and share my screen. There's a reason why I never do PowerPoints. Somebody is going to, I think this is good. Somebody will pipe up if it's not working, right? Okay, that's great. This is the support. Okay, guys. So I decided to take on a bit too much, I think, to be compressed into this one the time that each of us has, only because Hong Kong is generally known as such a very arbitration-friendly jurisdiction. In my mind, I didn't actually think that we would have so many interesting cases to discuss about the Hong Kong courts actually setting aside or not enforcing an arbitral award. But as I did my research, that turns out to be wrong, because my topic today is to not only talk about recent case law in enforcement and setting aside of arbitral awards, but it was also to talk about kind of the implementation of the CISG here in Hong Kong under Hong Kong law. I'm going to try to fit in both, but Lizzie has an even more interesting topic after me, so I'm going to make sure that I have enough time for her. Let's start first with the cases here in Hong Kong. There are three cases that really caught my eye, and I actually think probably are the only ones since the last HK45 annual update. Somebody can happily correct me, where the Hong Kong courts have actually decided to set aside or not enforce an arbitral award. Now, these are Arjun Williams, Not even going to try to pronounce this, so Sun Fung Timber, or GD versus HY. Now, I'm starting off with Arjun Williams because to me, in my mind, this is actually quite interesting from a legal perspective. What happened here in Arjun Williams is we had an HKIAC final award that was ultimately set aside by the Hong Kong Court of First Instance. And the reason why the Honorable Justice Chan that we love, at least we in the arbitration community love, said is because the arbitral tribunal actually went outside the scope of their authority. Now, the facts in this case is actually quite important or quite interesting to hear because honestly speaking, with my experience in arbitration, I could see possibly where the arbitral tribunal was going, and at the same time, I could also see the argument on the other side. So basically, in and around 2005, Arjun Williams and EXCO entered into a joint venture contract to establish a mainland Chinese joint venture company. Now, in about 2010, a dispute arose between the joint venture partners, and so respondent, which in this case is EXCO, applied to the mainland Chinese courts for the dissolution of the joint venture company. Now, in 2013, the Chinese court ordered the dissolution. And in that respect, the process started to continue. Nevertheless, in 2018, respondent then commenced an HKIAC arbitration against the applicant, which is Arjun Williams. And in this HKIAC arbitration, EXCO basically alleged that Arjun Williams had possession, custody, or control over certain account books and documents of the joint venture company. And two, they requested an immediate return and also an immediate right to examine the joint venture documents from from Arjun Williams to EXCO. Now, during this arbitration, because the mainland Chinese court had already ordered the dissolution, the Chinese court also formed a compulsory liquidation group in order to process the liquidation. But while this was all going on, the arbitral tribunal issued a partial award. And the arbitral tribunal in the HKIAC, the partial award basically found that on a factual matter, they agreed Arjun Williams did have possession, custody, and control of the joint venture company's documents. But the tribunal held that EXCO did not have the right to have such documents. And instead, it was the compulsory liquidation group that had the right to possession. So in essence, basically, the arbitral tribunal in the HKIAC arbitration rejected all of EXCO's claims. However, since it was a partial final award, the arbitral tribunal then invited further submissions on the order that on what the parties' positions would be to how the JV documents should be disposed and to facilitate the proper liquidation of the joint venture company. Now, at this point, Arjun Williams obviously raised an objection and said that the tribunal had no jurisdiction to take any further action because the issues raised by EXCO in its request or notice for arbitration had already been decided. EXCO, on the other hand, decided to submit further submissions requesting that Arjun Williams deliver the joint venture documents to EXCO in order for EXCO to make copies before then delivering the documents to the CLG, the compulsory liquidation group. Trying to take a second bite at the apple. Or second, alternatively, EXCO decided or requested that Arjun Williams deliver the joint venture documents directly to the compulsory liquidation group. Now, in its final award, the arbitral tribunal basically held that the respondent, or again, EXCO, was entitled to the remedy of procuring the delivery of the joint venture documents to the compulsory liquidation group. And this is key because this was a remedy that wasn't previously pled prior to the partial award, although the tribunal did state that it had jurisdiction under the arbitration agreement because it was part of the arbitration, part of the evidence and part of the information that was brought within the arbitration. Now, Arjun Williams, obviously dissatisfied with this award, applied to the Court of First Instance to set aside the final award. Their argument was that the award dealt with a dispute that wasn't contemplated by or not falling within the terms of the submission to the arbitration, or that it contained decisions on matters beyond the scope of the submission to arbitration. Their second argument was, as expected, the arbitral award is in conflict with the Hong Kong public policy. Now, The Hong Kong Court of First Instance agreed with Arjun Williams and decided to set aside the award. As the court stated, any claim of delivery of the joint venture documents was inconsistent with EXCO's pleaded case. Now, the court made a distinction and said that whether fact that an issue or matter is within the scope of reference of a particular dispute in an arbitration versus whether the arbitral tribunal has jurisdiction to decide the matter by virtue of the parties' arbitration agreement, there is separation and distinction there. Second, the court also had found or had stated that the scope of the HKIAC arbitration was the dispute relating to respondent's claim for delivery of the joint venture documents to respondent itself, and not its right to a proper liquidation of the joint venture company. This right was never raised in a respondent's notice of arbitration, and it was only raised once the arbitral tribunal invited further submissions on that particular topic. And third, the court also found that it was extremely important to the parties' due process rights to know well in advance before the hearing, to the full extent as possible, the pertinent claims and remedies that are sought so that a party has the ability to consider any and all possible defenses and strategies. So this was quite an interesting case because oftentimes in practice you will know or you will see that issues aren't always raised in a notice or request for arbitration. There are always times for parties to raise additional claims, so long as that is connected to the set of facts or legal arguments that have already been submitted. But in this particular case, the Hong Kong Court of First Instance found that the tribunal still went outside the scope of its jurisdiction or authority, and therefore the final award had to be set aside. Now, moving on. The next case, and I'm just going to talk really quickly, the Sung Fong Timber Company. This dealt with a mainland Chinese award that was in the process of being enforced, but one of the parties interjected, basically the respondent, interjected and requested that the enforcement order be set aside. Now, this situation is a little bit more unique in that the court found that even though it's very difficult to prove fraud, the reason why this award was not ultimately enforced was because the underlying agreement was a sham, it was fake, and the arbitration agreement was therefore not valid. Now, the court has always said that it is difficult to prove, but in this particular case, there was sufficient evidence. I mean, looking at the name itself of the respondent company, Sun Fong Timber Company, you would expect, as in the name, they sold timber. However, the contract or underlying contract at issue was for the sale of marble. And not only that, this contract that was allegedly executed with the other party was executed during a time when the shareholders of Sun Fong Timber were in dispute with one another and in the process of winding down. Now, I'm not going to go into details about this case, but this is an example where the court in Hong Kong will step in when it is clear that a due process violation has taken place because the company itself was never notified, one, of the contract, but two, of the underlying arbitration, which was the Zhangjiang Arbitration Commission, and the arbitration from beginning to end, including the issuance of the award, took 4 days. Now, the next case that I will jump quickly to, although this one I think is quite more simple, but interesting because in this particular matter, in GD versus HY, the Hong Kong Court of First Instance again set aside an award, but this time it was an emergency arbitration award. And the reason why this award was set aside was due to a lack of a valid arbitration agreement. Now, the underlying agreement involved a loan agreement between the two parties that were involved in the arbitration or the emergency arbitration, but the loan agreement contained multiple parties and the loan was continuously extended. The initial dispute resolution clause in the loan agreement was for litigation in the Hong Kong courts, but by the 5th extension letter, one of the parties inputted an arbitration agreement, but not all parties had signed that extension letter. This emergency arbitrator decided that he did have jurisdiction because the parties involved in the arbitration signed this extension letter. However, the loan agreement required that any variation to it required the signatures of all parties. And for this reason, the Court of First Instance decided that since no valid arbitration agreement existed, the arbitrator did not have jurisdiction to make his determination. Now I'm going to try to jump really quickly to the implementation of the CISG in Hong Kong. It's a very long topic, and I know that HK45 is going to hold a detailed webinar on this. So I'm just going to kind of give you a quick overview. Basically, the CISG is the United Nations Convention on Contracts for the International Sale of Goods. For all of you, if you haven't heard of it through the VISMUT or the VIS-EastMUT, you need to register as an arbitrator so that you will learn more about the CISG. The CISG basically has been signed or ratified by 94 jurisdictions worldwide, which represents 2/3 of the global economy. And the reason why it's important is because prior to the handover in 1997, the CISG did not apply in Hong Kong, and that was definite because the UK has never and still hasn't ratified the CISG. However, following the handover, a question arose as to whether or not the CISG applied because China is a signatory. But China at the time did not include the CISG as a list of the treaties that would be extended or implemented to Hong Kong. And so you see academic discussions going both ways. And even now to this day, you have courts worldwide deciding in both ways. For example, recently in February, the New York court held that it did apply to Hong Kong companies, whereas in the French Paris Court of Appeals, they've consistently held it doesn't apply. The DOJ has answered that question by implementing the Sale of Goods Act or Sale of Goods Ordinance on 29 September 2021. The DOJ anticipates that the CISG will be implemented by the third quarter of this year. It's going to be dependent on when China makes its declaration or makes a declaration to the CISG depository. I've taken a lot of time, so Lazy, I'm going to turn it over to you.
Hi everyone, I'm Lizzie, and welcome to my office in the Metaverse. In January this year, I hosted the first ever international arbitration gathering in virtual reality, and it was so much fun. There were about 10 of us, and 3 of us participated and advertised, just like you see me now. And while the technology is still a little glitchy, and the avatars look cartoonish, the experience does make you feel like you're present with others in a way that I think 2D video doesn't achieve. I'm so excited to be here, and I'm very grateful to HK45 for the opportunity to share a little with you about the metaverse, virtual reality, and the relevance to Hong Kong and international arbitration. And before I pass it back to Lizzie on Zoom, if I can leave you with one thought, it's this. It was something that the founder of Facebook, Mark Zuckerberg, said. There's the physical world and there's the digital world. And increasingly, the real world is a combination of the two.
Now, when I talk about the digital world and the metaverse, you don't have to be in virtual reality like I was. Nor do you have to spend your days gaming, scrolling through Instagram or TikTok. As knowledge workers, we already spend the vast majority of our days in front of the computer, drafting documents, communicating via email, and doing research on the web. And thanks to COVID, we're now spending an increasing amount of time building our professional relationships online too, be it staying in touch with colleagues and clients, sharing ideas through webinars like this one, building our profiles via social media like LinkedIn, and even attending virtual hearings. In my own case, I joined Alan Overy in February, and while I haven't yet spent a single day in the office, I already feel deeply embedded in my team and connected with my colleagues. It's a misnomer to say that we're working from home. We've just formalized the switch from working in a physical space called an office to working online. And what is being called the metaverse is simply the next step in the evolution of the digital world. There's been a lot of excitement, some would say hype, about the metaverse, with Bloomberg estimating a US $800 million market opportunity in 2024. It won't have escaped anyone's attention that last October, Facebook changed its name to Meta and committed to investing at least $10 billion a year on the metaverse for the rest of the decade. And even in Hong Kong, our own metaverse company, The Sandbox, has seen a surge of interest It is one of the most popular metaverse platforms at the moment for buying land. Ocean Park is going to develop virtual experiences and creative content there. PwC Hong Kong became the first major professional services firm to buy virtual land in the sandbox. On Tuesday this week, the South China Morning Post announced its virtual game on the sandbox, where you can do a virtual tour of the iconic Starfair Pier and take a virtual ferry ride and do quests there. 3 Hong Kong, the mobile network, just announced this month that its customers will be able to use cryptocurrency to pay their mobile bills. And this is advertised as providing customers with a new spending platform in the metaverse. But the metaverse actually isn't new, and I would argue that it actually existed in an embryonic form from at least 1996, when Korea issued, or when the South Korean gaming company Nexon launched the first ever massive multiplayer online role-playing game called Kingdom of the Winds. Now, let me offer some definitions of the metaverse for context. One is that the metaverse is a persistent digital world in which we each have a presence. Another is simply that the metaverse will be the internet in 3D. That is a more immersive experience. Either way, I think improvements in technology are going to further increase the utility of the digital world, and further strengthen its gravitational pull. Now, besides what I mentioned earlier about the sandbox, why is all this relevant to Hong Kong and international arbitration? First, let's start with virtual reality. Now, cast your mind back a decade or more to the iPhone 2. It was niche, it was buggy, there wasn't a whole lot you could do with it, and perhaps you didn't even have one. But contrast that with the iPhone 13 and other smartphones in your pocket today. They're ubiquitous, high performance, and indispensable to your personal and professional lives. Virtual reality is perhaps at the iPhone 2 stage, but the direction of travel is clear. And similar to other advances in communications like telephones, email, video conferencing, VR in the fullness of time will help make it cheaper and more convenient to conduct international commerce and manage complex legal proceedings across countries and time zones. Now, if rapper Travis Scott can host more than 12 million concurrent users in a concert in Fortnite, why can't we host an arbitration in virtual reality or even an international arbitration conference? You've seen me in my avatar already. Some might say that it looks better than I do on Zoom. You might be surprised by how quickly virtual reality improves from here. Now, second, as we spend more time in the digital world, so too will the digital economy grow with it. And already today, 7 of the world's 10 largest companies by market capitalization offer either a window to the digital world, like Apple and Microsoft, monetize our attention in the digital world, like Facebook, Alphabet, and Amazon, or produce semiconductors which enable the digital world, like NVIDIA and TSMC. And if we look beyond that, there is another $1 trillion of market capitalization in companies like Tencent, NetEase, NCSoft, Nexon, Epic, Unity, Activision Blizzard, and Roblox, whose whole business model is to create and operate digital worlds. We might dismiss them, call them games, but they're really communities in which millions of people are emotionally, socially, and financially invested. And if you understand the allure of the digital world, then you can also begin to understand the appeal of digital native assets like cryptocurrencies and NFTs. And as we spend more time inhabiting digital worlds, the complexity and richness will inevitably lead to novel disputes and legal issues. Now, it's too early to make sweeping pronouncements about what the legal implications of the metaverse will be, or how disputes there will be resolved, but we can already see interesting questions arise. For example, how will disputes be resolved in the metaverse? Now, let's start with disputes against metaverse platforms. Many of them have terms of use that include dispute resolution clauses. Hong Kong's own digital world, the Sandbox, elects Hong Kong law as the governing law, and the Hong Kong courts as the dispute resolution forum. And elsewhere, Decentraland uses ICC arbitration, while Meta's Oculus uses AAA arbitration. But I don't know if it'll be a simple matter of just reading the terms of use. For example, could these choices about dispute resolution be challenged by a majority of users within a decentralized metaverse platform? And what about disputes between users? For example, if a user creates a digital asset, maybe some ad, and they sell it, what are the terms and conditions that would apply to that transaction? Some NFT transactions might include smart contracts, but even those might not necessarily include a dispute resolution clause. And even if there was a dispute resolution clause, how could it be coded into the smart contract itself? And even if you were able to get an arbitration award at the end of it, what enforcement issues on-chain and off-chain might arise? Another potential issue is identity. Many of us already spend more time working online than offline, not to mention connecting online with our family, friends, and colleagues. Some of us use pseudonyms, like on Twitter or Instagram, and sometimes we use our real identities, like on Facebook. But will we soon be obliged to legally recognize our digital identities as equal to, or even more important than our real legal ones? Or can we remain anonymous? For example, the UK Jurisdiction Task Force issued digital dispute resolution rules, which allow parties to remain anonymous vis-a-vis each other. The rules, the people who created the rules said that the rationale for this was to reflect the fact that the parties may have transacted anonymously on the blockchain in the first place. Could party anonymity become the norm in international arbitration rather than the exception? And one of the founding principles of cryptocurrency is anonymity, but will governments eventually demand a way to trace ownership to a legal person or entity? And this question has already arisen in the context of international sanctions against Russia, where experts have suggested that cryptocurrency tools can be used to evade sanctions. And a final question, and certainly not the least of all the issues, is what happens when states engage in the metaverse? You might have seen that Barbados has recently purchased land on Decentraland and has claimed digital sovereignty over that land and says that it will build a virtual embassy there. Does this virtual space give Bermuda the same sovereign rights that it has over its physical territory? Do diplomatic immunity rules apply? Bermuda's actually hired international legal counsel to consider this, so it certainly considers this to be important. Or might states be subject to the same terms and conditions when they buy land in metaverse platforms, just like everybody else? These are the issues with which our profession will have to grapple with as the metaverse becomes increasingly relevant for our clients and also for ourselves. So my final thought for you before I sign off is just the metaverse is here and we should all learn about it. Thank you very much to HK45 for the chance to be here. And I hope to see you all online, offline, or maybe in virtual reality.
Thank you, Lizzie. Unfortunately, we don't have time for questions. Thank you to all the speakers for sharing their insight, and thank you for all the audience dialing in from everywhere. We hope you enjoy this webinar. We hope you take care, and we'll see you again soon. Thank you. Bye-bye.